How does a young litigator who has just joined the profession and who wants to make a name for himself in litigation, uh, get the field experience which is necessary to be able to, chalk out his own future, few decades or maybe a few years down the line? When I started my practice of law, it again seemed an impossible task. How do you take a step ahead? Of course, getting business and meeting more people, understanding the law, those were aspects which were to be dealt with later. The first and foremost aspect was how to understand the art of advocacy. There have been a lot of people who've tried to understand it by looking at judges, by understanding looking at other lawyers, by trying to understand how this court craft works. But I can tell you from experience that unless you stand before the judge and you interact with the judge or about the file in front of you, you will not be able to understand what goes on in the mind of a judge and what you need to do to prepare yourself for those arguments in the future for your own cases. However, there are several places where you can get this kind of an exposure very, very quickly and with great depth as well. Those places often are offices or the chambers of government lawyers, because government lawyers will always have so much work with them that they just cannot handle all of it by themselves. They cannot appear in all of their cases by themselves. And in those situations, even be it criminal counsels or be it civil counsels, in any situation, the government is anyways the biggest litigant in the country. Half the cases in the country are anyways filed by the government, because criminal cases, civil disputes, all sorts of matters, the government is the first to rush to court or is there to defend itself when others rush to court because of government intervention. Government lawyers get paid very little money per case, but they do make a substantial living for themselves working just on volume. As a lawyer, as a government lawyer, the government lawyer understands that he cannot do the whole thing himself. Therefore, he goes and distributes his work among several juniors who have to, of course, be competent, and gives them the opportunity to argue with a free hand, with the noted instruction that, of course, if there is any big stake or if there is any matter being finally decided, at that point of time the counsel himself should be called. The junior should not argue it in entirety. I myself had a senior who was kind enough to give me this opportunity, the same way he did every single other junior in his chamber. The senior had only one dialogue or in just one statement for every single junior of his, which is that you win or you lose, it does not matter. Nobody should laugh at you in court. That is the only criteria for success that we have over here. You should not be mocked by anybody inside the courtroom. So, with those instructions, all of us would head out every single day and face judges, face opponents, face lawyers several decades elder to us, and get that necessary court exposure, sometimes by losing, sometimes by winning, getting that exposure and getting the necessary experience and understanding advocacy at its most raw form. A lot of times people have also asked me, counsels, junior counsels have said that they've not been given opportunities to argue by the judge because the judge mandates that if the name is not there on the wakalatnama, then we will not let you argue. There are, of course, a few judges who have always held that, and rightly so, they have their own reasons. But majority of the judges, be it in district courts or in the high courts or in the Supreme Court, will not object to a junior counsel trying his mettle and trying to prove himself in a court of law. Recently, Justice Pratibha Singh of the Delhi High Court was kind enough to recognize the standing of a junior, of a lawyer whose name is on the Wakalatnama, and the Honorable Judge went on to say that if the junior works in the same chamber as the lawyer who has his name on the Wakalatnama, then that lawyer cannot be called a mere proxy counsel, especially if he is ready with the facts of the case and he is ready to argue the matter, then he shall be allowed to argue the matter. That, of course, is a very welcome judgment, but we have been doing it since the past several years, and there have been people before us who have been doing it for several decades. They go through the trials and tribulations of running around in a court of law without any sanctity given to them because they don't have their names on the Wakalatnama, and despite that, they go ahead, they make their submissions, and they try to get some fruitful justice out of the situation. Even in my case, what I used to do was every single time I would appear before the court, I would say that, my lord, I appear as a proxy counsel. My senior is not available today. However, if my lord permits me, I would like to point out these few things to the court. The moment I would do that, there were two benefits. One was that the judge would understand that I am trying to make some submissions, I'm trying to get some court exposure, and the judge would hear me out. And if the judge was inclined to grant me the relief that I was seeking, the judge would go ahead and grant me the relief. Be it, allowing an application, allowing my entire petition, dismissing my opponent's appeal, or whatever be the case. But the bigger benefit was that in this kind of a situation, the judge understood that indirectly what I was saying was, please allow me to make my submissions, but if you're going to dismiss my case, then at least let me call my senior on another date or maybe after passing over the matter, and then dictate your order before that senior. What that used to do was that ensured that I get all the benefits of arguing a matter before a judge, but I faced none of the repercussions. Of course, maybe one out of 100 times this would happen that the judge would, after hearing me out, refuse to grant me any opportunity to call my senior and would pass orders in my senior's absence. However, every single time I have gone back to my senior with this report that orders were passed, my senior would always say that you anyways did your best job, and if I would have been there, the outcome would not have been any different. And he was right, and I knew that too, because the 99 cases that I was arguing, because of the court exposure, which gave me the confidence, which made me prepare my cases better, which gave me more court exposure, ensured that in those one or two circumstances where I was not able to play along with this little gig that I have and not defer adverse orders until later, I was still able to do a very, very good job so as to keep my senior in the knowledge that yes, even if he would have been there, nothing better could have come out of it. That is one way that I pulled out several years of law practice as a junior advocate to somebody else, and I learnt several years worth of experience in the matter of just a very, very short amount of time. And that is something that you, as a junior counsel, or maybe someone who is about to step into the world of litigation, can also consider.